Hello, hello, hello. This is Attorney Mike Girl. I'm coming to you from Chicago. As usual, sorry I had a little mix-up. I couldn't find where I put my clip. But now I've got it. We've got crazy Karens. I'm warning you right now. Do whatever you need to do to protect your sanity, because you're going to lose your mind. Oh, and before I forget, I need to thank Kathleen Estrada. I got some good clips from her. Sammy Lee sent me this little nugget for the intro. It's good. And that's it. That's it for today. Let's do this thing, shall we?
All right. Next, we have Ms. Barton. Ms. Barton, you've been charged with a class of criminal offense as well.
Not you. Casey, not you. Take a seat over there.
Are you Ms. Barton?
I'm Elizabeth Windsor, dead. That's in the Queen of England.
She's Barton Marley.
Okay, all right. Madam, you've been charged with a Class B misdemeanor criminal trespass as well. The range of punishment on that type of offense in the state of Texas is up to 6 months in the county jail and a $2,000 fine. That bond has also been set at $2,500. Do you have any questions regarding your charge or bond amount?
I've already signed up for pre-trial release of personal bond.
All right. Again, they did not grant you personal bond because there's no reference on this paperwork. Is there a reference you want to give me that?
Yeah, the Queen of England. I want the King of England as my reference, Johnny Depp.
All right. So ordered, madam. Take care of yourself.
Go check in with your officer.
Girl. But I proved it to be. Girl, no, don't do that. Just, I will mute you now, Miss Jones. All right, now, no more girl, Miss Barnett. Now you tell me.
The matter before the court this morning is the case entitled Aaron A. Jacobs versus Adrastea K. Andrews, case number 22AP264. Appellant Adrastea K. Andrews is self-represented. Appellate.
That's all you need to know right there. I did another one from this. Karen appeals her case or whatever. We have another Karen representing herself in the appellate court. It's the appellate court of Vermont. I think I said Delaware in the other one. They're both Vermont. Appellate courts are incredibly boring unless a Karen tries to do it herself. Then it gets pretty spicy.
He did not file a brief or request to argue.
All right, Ms. Andrews, please introduce yourself and then you may proceed with your argument. You understand you have 5 minutes.
Thank you. My name is Adrastea Andrews. Thank you for your time. I just need a moment to breathe while remembering the other party didn't respond. Furthermore, I have...
You'll see why the other party didn't respond.
The order here, which I am appealing, and it is contingent upon a prior ruling of Catherine Hayes. However, in this argument here, what I'm stating will be about Elizabeth Mann, as it was contingent upon Catherine Hayes' ruling of custody in the way of Mr. Jacobs. What I have done to prepare is write briefly some notes on how Elizabeth Mann has neglected her procedural course on this event, and I'd like to state...
I gather that Elizabeth Mann was the judge at the trial level, and it's incredibly disrespectful to just name her in the... It's the least of her problems, but that's incredibly disrespectful, and you're dealing with 3 justices. They're not going to say anything, but they're all thinking, how rude.
These briefly, and then furthermore add additional hardships my family and I are undergoing currently to this day. So I would like to state on 9/19/2022, this is 2 years after the initial case, and within the 3-year time period, I have not seen my children because of this. First mistrial in 2019 by Catherine Hayes. So here we have in 2022, September 19, Elizabeth Mann states, prior to the trial starting. Now, let me remind you, this is prior to the trial starting. While on record, Elizabeth Mann states, this is a motion to modify, and asks the bailiff if he had a nice vacation.
You heard it.
That is improper. Then he answers and she responds, did you bring me back something from Louisiana? I have this on audio transcript. I'd love to play it for you, but I've made some notes. Now, this is under the 14th Amendment. That is against the law. There is no bribery allowed in the court. I know this from previous clerks that have made jokes about donuts with my younger children and how gifts are not allowed, but they always requested them. Not funny, against the law, 14th Amendment.
Okay, now this I can't take. The donuts and the asking about the vacation is one thing, but claiming it's not funny, no, it's hilarious.
Then there was a problem with the calendar for this day, and there was much to do about that with the bailiff, and the procedure had issues. That is Title 13. That is against the law as well. Talked a while trying to.
The justices, and they should be, but are completely stoic. There is zero reaction the entire time. That's the way it's done, but I give them credit under these circumstances.
Get this done was a quote Elizabeth Mann says. Contempt of court prior. This is all prior to starting on the record. This is all contempt of court. Now, this is a modification for full transfer of custody, which I should have been granted. Well, without real, substantial, unprecedented change, the circumstance to benefit my children did not happen. However, I placed much evidence on this day that she was not willing to look at, much like Catherine Hayes. Nothing had taken place prior to 2022, but she only wanted to hear after what had happened. So I will enlighten you, therefore. She interrupts me immediately every time I speak. I have evidence of this. She hardly lets me speak every time she does ask me a question.
Your Honor, may I?
No, you may not.
I have proof of this. Now, I have no contact information for visits and no phone calls with my children for up to 6 months at this point, again, after the initial 2019 hearing of Catherine Hayes. She makes no remedy for this. That is against all 9 Vermont statutes. There were no approvals.
All 9 of them. I mean, I would think they have more than 9 statutes in the state of Vermont, but I don't know. But whatever she was prattling on about violates all of them.
Of any of the supervisors, I had requested upwards of 30. Catherine Hayes' trial had already remedied that was not allowable. He was not allowed to choose my supervisors. Extrinsic fraud continues after this with the Winston Prouty that I had gone to for a year and a half, that Catherine Hayes would not see the visits, and neither would Elizabeth Mann, from Amy Newton, Sally Struble, Michaela Stockwell. I had 2 witnesses, my father and...
You have 1 minute remaining, ma'am.
Thank you. I also had proposed witnesses that weren't able to hear, that were supervisors. I'm still unable to see my children up until this point. Nothing has gotten anything better. I am suing the town for lack of appeal remedy. To see my children in school, I have educational rights. I have medical rights. I am not in communication with any medical provider or any school, as I am not allowed there. That is against all Vermont statutes. This is a huge 14th Amendment issue and Title 12 and Title 13, and I am appealing 100% the Elizabeth Mann trial as it was contingent upon a mistrial. I rest my argument.
Justice Eaton, I think you're muted.
Do either of you have any questions for?
Oh, hell no. Hell no.
Not from Justice.
I do not, Justice Eaton. Thank you.
That's fine.
Okay, very well. Bailiff will call a conclusion of the case.
This is great. You created the problem you have, not me.
I object to this whole hearing. Let's go. I'm done.
All right, Mr. Walker, please prepare another order on contempt.
Can you hear me?
Miss Williams, I can hear you.
Okay.
Miss Williams, case number C23F0595LT, Gabriel Management versus Connie Williams. And Attorney Fanous, if you can place your appearance on the record, please.
Good afternoon, Your Honor. Pardon me. Good afternoon, Judge Elias Fanous, appearing on behalf of the plaintiff, Gabriel Management.
Once again, thanks to Kathleen Estrada for this one. This clip is just awful. It's excruciating.
All right, thank you. And Connie Williams, you are here as well, correct?
Yes.
All right. We are here today for a bench trial on a non-payment of rent case. We were here yesterday as well, and it seemed to be that there wasn't necessarily, and Attorney Fanous, correct me if I'm wrong, wasn't necessarily a disagreement as to what was owed, but a disagreement as to how much time Ms. Williams would have to get that paid up. Is that an accurate recitation of what's happening?
It is, Judge, and I'm happy to report to the court, and maybe this will resolve the matter right now. We would give Ms. Williams to the end of the month to get that taken care of. We do have a signed G-card packet from Ms. Williams, as she did state that yesterday, that has been verified. We're willing to give Ms. Williams to the end of the month to get that squared away.
All right, Ms. Williams, are you wanting to agree to those terms, that the amount that we talked about tomorrow, which we'll state again, that's owed will be paid by the end of the month?
Yes, but can I say something? But I do agree, but can I say something, please?
What is it you want to say?
I talked to Maria this morning, but I talked to her yesterday as well, and I told her that I would be able to give her $2,150, and then can she give me a grace period to come up with the remaining?
That's what I'm telling you, ma'am. I got the notes here in front of me.
Oh, okay. So you got the notes to Maria.
So then you just keep working with them at Gabriel Management. You're not going to have any issues.
Oh, okay, great. Okay, yes, I agree then.
Okay, then Attorney Fanous, if you could, please place the formal terms of the agreement on the record.
Thank you, Judge. This concerns a property in Mount Morris. There's a current amount due and owing right now, Your Honor, of $6,133. For costs associated of $155, reflecting a total to retain of $6,288. We do have a signed Sarah statement. What we've agreed to do for Ms. Williams, Your Honor, is to give her to the end of the month to get that payment processed and for her to make up any deficiencies from that payment as stated with Gabriel Management. So the writ date would be June 30th of this year.
Okay. Okay, thank
Can
you.
you please state the terms of it, though?
I'm sorry, what did you say, Ms. Williams?
I'm asking that I'm helping my sister and to state the terms of it, because the remaining balance will be $2,000. He's saying that it's $6,288, but minus the $1,190 that she's getting from Sarah.
Here's where it gets good. This is her sister piping in and not helping anything. Oh, it's so aggravating.
Takes it down to $4,298, and that he has to the end of the month to make a payment of $2,150.
Can you not hear me?
We can
All right,
hear
we
you
just
fine,
muted
Judge.
that person. We just muted that person because that's not Miss Connie Williams speaking, and if anyone wants to speak in a case and they're not the plaintiff or the defendant or an attorney, then obviously they have to identify themselves, tell me who they are, and tell me why exactly they are speaking. So let's unmute that person so that they can tell me who they are before I let them say anything.
Okay, can you hear me?
I can hear you now because I just unmuted you. What is your name?
Okay, thank you, and I'm sorry about that. I just wanted to make sure. My name is Anita Amodia. I am the sister of Connie Williams, and I have been trying to help her.
Stop.
Pardon me?
Stop talking for a moment. You need to slow down and stop. This is an official court proceeding. You can't just keep talking like that. You have to let me do my job. So one more time.
I understand that, but it's hard to hear you, so I'm not talking over you.
You are talking over me as we are speaking right now. Are you finished?
Yes, I'm just trying to hear you.
Tell me what your name is slowly.
Am I allowed to speak now or no?
I just asked you to tell me your name slowly.
Okay, I didn't hear that. My name is Anita
Bullshit. That is just passive aggressive stuff. Her name's Anita Amodia. It really should be a Anita Ballgag, but
Odia.
All right. Well, you didn't hear me, Anita. Miss Amodia, you did not hear me because when you're speaking over me, you can't hear me. That's the way the technology works. So you have to stop doing that. Anita Amodi, how are you related to Miss Williams?
I am her sister.
Miss Amodi, do you have a guardianship or something like that over Miss Williams?
I do not.
Okay. Is there any reason Miss Williams can't speak for herself?
My sister asked me to speak because there are certain things that said on the call that she doesn't understand or clearly understand what you're asking of her. So my sister reached out to me to assist her.
So Miss Amodi, here's the situation though. You can't do that. If Miss Williams, who I'm going to tell to get back on the phone, doesn't understand something, she needs to be explained that by me or by Attorney Fanous, not by you. So please put Ms. Williams back on the phone so that I can have a conversation with her and make sure that she understands what's going on.
She's on the phone.
All right, Ms. Williams.
Yes, ma'am.
Okay, Ms. Williams, I am talking to you and only you, and I only want you to answer, okay?
Okay.
All right, so what Attorney Fanous has stated is that the total he believes, and you can correct me if you think he's wrong, he believes that the total amount owed as of right now is $6,133 plus $155 in costs for a total of $6,288. And he acknowledged that Sarah is going to pay a portion of that. And if you get assistance from anyone else that's going to pay a portion of that, that would be great too. And then you would owe whatever the remainder is on top of, aside from what Sarah or whoever else is paying. And then that would need to be paid by June 30th.
Yes,
do you understand?
Okay. Mm-hmm. But when I was speaking with Maria this morning, she said my balance was only 4,000. After Sarah take theirs out, it'll be $4,295. So then that's why I came up with the half that amount, which was $2,150. And then once I paid that, she said she had to talk to her manager and see can I get on their payment plan. But in between that, I reached out to DHS and put in a MCR form, but she said sometimes it takes a week, or it goes in rotation on how you turned your application in. So I don't know how long that process would take. So
oh my God, pay the damn rent through a combination of government assistance and you paying it in 30 days. Or get out. It's not difficult.
That's my next step. But then I am working.
Your Honor, if I may.
Yeah, go ahead, Attorney Fanous.
Ms. Williams, I understand exactly what you're saying. And what we're telling you is Gabriel Management has agreed to that. But for the purposes, until that check is received by G-Card for your Sarah funds, this is your balance. But you've already talked, and we have notes in the system at Gabriel Management that you're going to come in and pay $2,150. We are giving you until the end of the month to do that.
Okay.
But the total balance has to be reflected on this document.
Yes.
So there's no confusion as to what the total amount is owed. Once the SARA payment processes, that balance will then decrease. Once you make your payment, it'll decrease again. And then you get on a payment plan with Gabriel Management.
Right. Thank you. I understand. I agree.
There should be, and I hope I'm explaining it clearly enough. Do you have any other questions at this time?
No.
Can I sign your name to this document so we can have Judge Hammond sign it, and so then it closes out the file for you?
Yes.
Okay. And just remember, you have until the end of the month, okay, to make sure you get that taken care of with Gabriel Management.
Correct.
Okay. Thank you.
All right, Ms. Williams, Ms. Williams, I need to swear you in real quick before we go forward. Ms. Williams, raise your right hand.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth today?
Yes, ma'am.
Okay, so you heard the terms of the consent judgment that Attorney Finis put on the record, and we had a conversation about it as well to make sure that you understand what you're agreeing to. And now after that conversation, is that what you want to agree to today?
Yes.
Okay. Because you have elected to represent yourself in these matters, I need to let you know that you have 3 days from today's date.
Actually, Judge, she elected to have Anita represent her. Sorry.
To ask me to set this judgment aside. It doesn't necessarily mean that I will, but if for whatever reason you change your mind over the next 3 days, you have the right to file a motion and ask me to set the judgment aside or essentially rip it up. You understand that?
Yes.
All right. And then finally, because you're appearing on Zoom and Attorney Finis is appearing on Zoom, you can either give him permission to put on the judgment that you approved of it via Zoom, or you can come down to the courthouse today and sign. Which would you like to do?
I would like for you to do the signing over to Zoom.
Okay, so where your signature normally would go, Attorney Finis is going to put that you approved of it via Zoom, and then you...
God bless her. She makes the right call in the end. That's a good deal they're offering. Let the attorney sign it for you. I'll give her credit.
We'll get a copy mailed to you, but because you're seeking assistance from both Sarah and DHHS, you're probably going to want to come down to the courthouse as soon as possible to get a copy of it so you can take it to them.
Okay, thank you.
All right, anything else, Attorney Finis?
No, Judge, we've submitted that judgment to the court. I sent it directly to Gail, so she should have it. And thank you very much, Your Honor.
All right, thank you, everybody. Have a good day.
You as well.
Thank you. Bye-bye.
Thank you.
If you haven't hit like and subscribe, I just want you to know that you're hurting Jack's feelings. Thank you so much, Purple Ghost Dragon and Matt Sale. I just wanted to say that in between here. Oh, and I should also mention that this gets worse.
Okay, we're in the District Court of Dulles County, Kansas. This is case number 2023 SC16. It's a small claims case involving the plaintiff, Tina Potter, and the defendant, Casey Clausen. Ms. Clausen, are you in bed?
No, I'm sitting on my couch with pillows.
Okay. All right, just looked like you were pretty relaxed there. All right, let me swear you in. Ms. Potter, you want to raise your right hand? I'm going to swear you in. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
You submit to the jurisdiction of the state of Kansas and the penalties involved of testimony, including but not limited to perjury.
Yes.
All right, Ms. Clausen, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You submit to the jurisdiction of the state of Kansas and its penalties, including but not limited to perjury.
I do.
All right, you can lower your hand. All right, this is a small claims case brought to the court's attention by you, Ms. Potter, and just reading this, it looks like you're looking for $3,090.50. All right, so state to the court why you think Ms. Clausen owes you that money, and give me any evidence that you have.
Okay, on March 27th of 2023, I did Ms. Clausen's taxes. She says she never got any.
Is she in custody? Or is she just wearing an orange shirt?
But more than 20, 40 bucks. I got her back a total of
custody.
Almost $9,000 with her and her dependent. I didn't tell her how much I was charging. I didn't even give her a price. She's the one that told me she was going to give me $3,000 for getting her that much back. Then she proceeded. Okay, me and her had a falling out because when I got my neck done, it was by a guy I was being with. That
She's got a small claims beef. She figures, I got nothing better to do. Let's zoom that in. Well, I got time on my hands.
I heard her tattoo. We had a falling out. Yes, I did tell Miss Clausen when I see her, I was going to kill her. I said out of emotion, anger, you mean feelings, you mean? I proceeded to tell her.
Yeah, yes, Judge. I did tell her I was going to kill her. And I said it out of anger. I just wanted to set the baseline here.
On the following day after telling her that, I apologized. And I told her taxes would be in her bank account on the 19th, which they did. She even reported telling Officer Baker that she was going to pay me, that she knows she owes me $3,000. To me, I don't know about Kansas, but in the state of California, when two people have a verbal agreement, that's a binding contract.
Ghost Dragon.
So I did her taxes. She got the money. She's the one that told me how much she was going to pay me. She's the one that told me she was going to give me $3,000. I agreed to it.
All right. Ms. Clausen, are you denying that you said that you were going to give her $3,000?
No, Your Honor, I am not. I did originally agree to.
Damn. She kicks this hearing off with, I told the defendant in the civil matter, I told her I was going to kill her. And now, but yeah, she's going to prevail. Unbelievable.
To pay her $3,000. I even asked her how she wanted, if she wanted it in like smaller sums, and she said she wanted it in $500 sums. And then when she threatened my life, I took that as a serious threat. I do have a restraining order out against her. And I felt.
Don't worry, we get to payment issues with the restraining order. It's so good.
Threatened for my life, and I did not want to pay her at that point. And also, the day of the 19th, it was not there until the morning of the 20th, the money. And
so when did she threaten you? Did she threaten you the 19th?
No, she called me during visitation with my daughter. I have court-ordered visitation with my daughter, and she called me that day with my daughter. I remember answering the phone call because she called me like 20 times that day. And I ended up answering because I was getting annoyed that she kept calling.
What day was that? Like
that was a Tuesday. I believe it was March 19th.
Okay, so the day that you were supposed to have the money in your account, but you didn't have it until the next day.
Yes, because I remember checking on the phone. I checked my account that it was going to, and there was nothing. And I checked that on the phone, and I told Gina, and Miss Potter, excuse me. And Miss Potter said, well, it should be there, and it wasn't there until the 20th.
But you had agreed to pay her $3,000.
I did, Your Honor. Yes, and I just took the threats as serious. So after that, I didn't want to pay her anything. And I don't see that I need to because I'm a single mother. I work 2 jobs trying to provide for my daughter and myself and pay the bills. And I need as much money in savings as I can get. And whatever you say I need to pay her, I'll pay her. But I don't feel that I need to pay her anything because
Your Honor, she doesn't have her kids.
Hang on a second. Don't talk when she's talking. Go ahead.
and I don't feel like I need to pay anything because of those threats.
Okay. Ms. Potter?
Your Honor, those threats had nothing to do with the agreement that we had. That threat was done.
I mean, she's actually right. As a matter of law, she's actually right. Those are two separate issues. You're here on a civil claim. What's before the judge is, do you owe the money or not? The threats are a big issue. They are. But there isn't some provision in the law that, you know, somebody makes a threat and your debt to them is wiped clean. That's a criminal matter. This is a civil matter.
A text message. It was never verbal. It was through a text message. Yes, I did call her. It was a Tuesday. It was the 18th when I called her and told her the money should be in her bank account, which I have evidence at the house. You know where I'm at. I'm in custody. But at the house, I have evidence because I had her bank account routing number. I had the bank account. I was calling and checking. She was spending that money quick.
All right.
Because I was always checking. The money was just going quick. Thousands quick.
You called her bank?
I have all her information.
You called her bank and asked?
I called her bank and I listened to the balance.
Okay.
Yeah, the first day when I first told her, $1,000 had already been taken out on the 18th.
Did you put yourself out there as her when you called her, or how did
No.
Okay.
No, you could just call it. If you have the routing number and the account number, you could just call and hear the balance.
Okay.
And the last four of the card number.
All right. Miss Clausen, it sounds like you had a verbal agreement to pay her $3,000. Really has nothing to do with any criminal activity unless she was trying to extort that money from you. And it doesn't sound like in civil court that that's what it was. It sounds like you both agreed to pay Miss Potter $3,000. So I'm going to order that you pay Miss Potter $3,000. I am looking at...
Yeah, this was for court fees, but I didn't have to pay those.
So you're asking for $3,090.50.
The $90.50 was court fees, but I didn't have to pay those.
Okay. Well, here's what I'm going to do then. On May 24th, 2023, I'm going to order...
I mean, I don't want to be a nerd here, but I'd assert the statute of frauds right about now and say we need a writing judge, but okay.
For the defendant, Casey Clausen, paid to the plaintiff, Gina Potter, $3,000 principal. It holds with an interest of 10% pre-judgment and 12% post-judgment. I can tell you that you both have full appeal rights, that if one or both of you don't feel like I acted according to the state statutes of Kansas, that you can appeal this finding and have it seen by a district court judge. You'd have to know how to do that. It has to happen within the next 10 business days. So make sure if that's what you choose to do, that you do that in that amount of time. You'll pay Ms. Clausen personally. You won't pay the court. It has nothing to do with the court. The court's not a collection agency. It doesn't do those things. So that will go directly between Ms. Clausen and Ms. Potter. Do you have any questions that I can answer?
Your Honor.
What if there's a protection order?
Your Honor, there is a restraining order out, and I do not feel safe around her, and I'm willing to make payments because I don't have $3,000 right now because I've been fixing my car. That is why a lot of money has been taken out from the taxes. I'm willing to make payments of $500 to her.
That's up to you. You'll have to work those things out. The court's not going to direct where those things go. If you, so there's a restraining order between her and you. So that may have to go through if she has an attorney, or I wouldn't be able to direct how those payments go.
Your Honor, could it go through a friend?
If it's a mutual person that you both trust, I guess.
I don't think he knows her.
Okay.
Your Honor, I don't feel comfortable going with somebody I don't know and giving a larger amount of money to somebody that I don't know.
Yeah, I would.
Because how am I supposed to know it gets to her? And then
Well, that's a shockingly reasonable and intelligent thing to say.
get another claim in court saying that she never received the money.
Did she just put it on my books?
At jail?
Yeah.
You'll have to work that out. Court's made it.
She wants to be paid in jail credit. The worst part is it makes sense under the circumstances. That's the way she knows that the money will get there. She won't be harassed. It doesn't violate the restraining order. I mean, as crazy as it sounds, it's a good idea. I can't even take it.
Judgment as far as payment goes, the no contact order may hold that up, but you'll have to figure that out. All right.
Heck, it's a double rainbow. Hey, Cal, look at that. It's a double rainbow.
There you have it. There you have it. I just, they go in themes like this sometimes. I wasn't looking for it, but I wasn't even going to do one. But then all I saw was Karen's acting crazy in court. So it was Crazy Karen night. That was a lot of fun. Big shout out to Kathleen Estrada again. I put a link to her channel in the description. Also, I want to thank everybody for the memberships. I'm trying to grab those as we go. I don't get to see them there, but people tell me. And I also want to thank everybody for the nice response to Natalie D starting a channel. I've been messaging with her today. I gave her the usual. I gave her the usual push into the pool that I do for people in this circumstance. And at some point, I just say, "You got to make a video," and that's that. We're not talking about this anymore. And she did. It was a lot of fun. So go check that out if you haven't already. And for those of you that did, I appreciate it. She's been a huge help here and sent me a bunch of great videos. So that's that. Happy Sunday night. I'll see you all soon.